दर्शकों नमस्कार, आपका स्वागत है आपके अपने चैनल कानूनी चर्चा पे। व्यूअर्स, यू आर वेलकम ऑन योर ओन चैनल कानूनी चर्चा। जैसे आप लोग जानते हैं, आपकी जानकारी में है, हम लॉ सीरीज पे डिफरेंट एपिसोड्स और डिफरेंट लॉ पॉइंट्स, डिफरेंट दिस पार्लियामेंट एक्ट्स, तो मैंने पिछले शुरू किया था वो एक गोल्डन ट्रायंगल पे बात शुरू की थी, कानूनी चर्चा शुरू की थी। तो गोल्डन ट्रायंगल में मैंने जो फंडामेंटल राइट्स 3 हैं कॉन्स्टिट्यूशन ऑफ इंडिया, संविधान के नीचे, वो 3 आर्टिकल मैंने रेफर किए थे, 14, 19 एंड 21। ये इंटररिलेटेड है, इंटरवोवन है, इनके जो इनकी एप्लीकेबिलिटी है, या इंटरप्रिटेशन है, या इनका जो मीनिंग है, या ये इसी पे इसकी आगे बढ़ाते हुए, तो पिछले मैंने आर्टिकल 21 पे बात की थी। राइट जो हमारा है, राइट टू लिबर्टी एंड दिस राइट टू लाइफ। तो मैंने बात की थी, इसमें 3 पॉइंट जो इन्वॉल्व थे, उसमें था कि लाइफ, राइट टू लाइफ, राइट टू लाइफ मीन के डिग्निफाइड लाइफ, देन पर्सनल लिबर्टी, राइट टू हैव पर्सनल लिबर्टी। तो उस थर्ड पॉइंट था उसमें, हाउ टू, इफ somebody has to be deprived, how he can be deprived from right to life and personal liberty, right to personal liberty, by, as per our constitution, article 21, as per our this procedure established by law. But Supreme Court judgments I have referred in A.K. Gopalan case, it was 1950 case. The very narrow view was taken by the Supreme Court of India. In that case, it was said that whatsoever procedure is available in preventive of detention act, the detaining authority has applied and legally detained the A.K. Gopalan, who was a communist leader. And afterwards, in 1978, in Menka Gandhi's, a broad view was taken of right to life and personal liberty. It was held that procedure established by law, it should have a fair and transparent applicability. Principle of natural justice must be adopted, and due process of law was made applicable by Supreme Court of India while dealing with the wherever it is, what, in order to see whether the procedure mentioned in a particular legislation, act, parliament act, has been adopted, principle of natural justice has been taken into consideration, and if due process, fairness of the process has been discussed in that judgment, and equally situated view as available in US courts, in US Constitution of India, due process of law has been adopted. The meaning of the procedure established law should be equally situated with the due process of law. Now, I have referred a few judgments in that. Right to life, we have concentrated earlier, right to life. We have also simultaneously dealt with 2 judgments. One was with P Rathian versus Union of India, and afterwards there was a Gian Kour judgment. In P Rathian case, it was held that right to die is also a fundamental right. Before that, there was also another judgment. This is a right State of Maharashtra versus Maruti Shiripati Dobal. In that case also, Bombay High Court has held that right to life includes right to die. Afterwards, in Gian Kour, these two judgments were overruled, and it was held that right to die is not a fundamental right. The relevant section 309 available in the independent court remained intact with the coming of the judgment of the Supreme Court in Gian Kour's case. The Gian Kour's case versus this state of Punjab. This judgment has come in 1996. P Rathian case. This judgment has come in 1994. Now, this we had discussed in earlier. So, at the end, I have also discussed a right to die with dignity. The law has evolved by the judgments, new judgments of the Supreme Court of India. That judgment was, in earlier episode, I had not referred the judgment, but I have discussed about right to life also include right to die with dignity, not right to die. But in some cases where where some patient is under critical condition, he is in a vegetative state, he is not, he is on life supports, mechanism, garcus, he is not, his body is not working at its normal by natural way. That if I will refer the cases how this right to die with dignity was recognized by Honorable Supreme Court of India. First judgment on the subject is Aruna Shanbaugh case. This judgment came in 25th of February 2014. What were the facts of this case? I will refer in brief. There was a nurse having name Aruna Shanbaugh in Edward Hospital, Bombay. What happened to her? She was molested, sexually molested, and however, the convict Sonlal was not convicted for sodomy, but he was convicted for assault and something more. And 1980, he undergone the sentence. However, the Aruna Shanbaugh remained under treatment in coma. She was strangulated by the accused Sonlal. After there was a scuffle, she resisted the rape. She was in menstruation stage. She was suffering from menstruation period, as the ladies undergone in monthly this menstruation. After he committed sodomy, no doubt he was not punished for that, and he strangulated her this neck, and her brain got damaged. She was in coma, vegetative state, and she was, however, then a social worker, you say, came, Kiran Birani approached the Honorable Supreme Court of India for asking the Supreme Court of India let she be allowed to die. Who? The Aruna Shanbaugh. On her behalf, she has filed a appropriate this petition before the Supreme Court of India. I think under Article 32 of Constitution of India. Supreme Court of India, after getting a report, medical status of the Aruna Shanbaugh, no doubt, the report was that she is suffering from, she is in vegetative form from the last 36 years, and it is not, she is on life support, but she is not eating in vegetative, or it is not possible for her. From the, then how was Supreme Court of India? No doubt, Supreme Court of India agreed that her sufferings are not 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 favorable, not favorable. That her life should be, that she should continue with this agony and sufferings, pain. But she said, the Supreme Court of India said that she is is has not made any declared will earlier, and she is not presently in a position, she has not a mental capacity to make declaration, give declaration, to to give a consent that she be allowed to die. She may be killed by adopting this medical interventions. It was also simultaneously held by the Supreme Court of India that Aruna has no any relatives, or cannot be considered as her next friend. No doubt, it was also the version of the Supreme Court of India that the nursing staff, the medical staff, paramedical staff available in the above this hospital can be a next friend, because they are taking care of her. But the staff, nursing staff, was not agree to that she may die by the intervention of some this medical treatment adverse to her natural death. Afterwards, but she died at her own by suffering with the pneumonia, this ailments. This, however, some mechanism should be there, and the nursing staff or staff of the hospital, medical staff of the, can approach to the Honorable High Court for the staff. I, as already said, was not in favor of going to taking such type of measure to end his her life, Aruna Shanbaugh's life. What happened now? This is a law developed regarding inesthesia. Anesthesia is a Ishamritu. But afterwards, for one more case, this common cause was a common cause society has approached the Supreme Court of India. A case was this case was decided, Common Cause Registered Society, on 9th of March 2018. 18, what has decided in this case, what Supreme Court has, as I already said, that during when a patient is in hospital, he must have her declaratory will, you can say, how he be treated if he is not recovering in his treatment when he is hospitalized, vis-a-vis his this medical treatment, sufferings of a disease, ailment. But during his lifetime, if there is a declaration, that declaration must be attested by two witnesses and registered, and this and its attestation, not registration, but attestation must be by a magistrate. A complicated procedure, I say. in common causes. This common cause society's case was evolved, and Supreme Court judgment but it was not practical. Many hindrances was being caused in implementation of this judgment of Supreme Court of India in common cause society or justice society's case. Thereafter, one more judgment came, and the Indian Society of Critical Medical Cure people came on the fore and approached the Supreme Court of India. They have contended before the Supreme Court of India. It is very difficult. Please simplify the procedure so that we can implement common causes judgment for this enthusiast deaths. I have already in earlier episode have said that two types of enthusiast with the intervention of medical gadgets, medical apparatuses can be made. One is passive and other is active. If by injecting something poison, you may say this is by removing life support. This is a passive method, by not giving further treatment to the patient so that the patient dies by a natural death. This is a passive, and active is some intervention of some medical treatment or medical you can say injection, this pills, tablets, etc. whatsoever medical drugs you can say. But in passive, then this judgment, Indian Society of Critical Medical Case, the practitioners approach, doctors approach that let there be a simplify. In that case, the bill which was required to be a form which was required to be filled by the patient when he is under treatment or during his lifetime, he must, and there should be a test. It was Supreme Court has given a liberal view that it may be attested by two witnesses. No need of attesting this declaration before a magistrate. It may be before this notary public or before a gazetted office. Simplification was then from now there is no legislation on intrusion so far. But on taking into consideration these judgments, this is common cause, and afterwards now this is a Indian Society case. This Indian Society of Critical Medical case, the procedure established, the guidelines given by the Honorable Supreme Court has simplified the procedure, and now whenever there an institution came, and then Supreme Court judgments, these judgments are now followed by the Honorable Supreme Court. In particular, I think it is Supreme Court of India exercises inherent jurisdiction under Article 142 of the Constitution of India in special cases, after getting report, after getting medical status of the patient, and when there is a report, there is a status, then patient advisable this staff, concerned hospital staff, or can be directed to allow the patient to die by adopting passive method. This is my today's in the earlier episode. I wanted that let there be a discussion in continuation of the earlier regarding Article 21. My concern was, which I have, that no doubt right to die is declared unconstitutional. Section 309 IPC is still there. What right to die? The Supreme Court judgment has now evolved the law, that right to, no doubt, right to die is not cannot be considered as a fundamental. It is unconstitutional. What right to die with dignity? If somebody is suffering, a patient is suffering, and he is in vegetative state, he is not responding to the medical treatment being provided to him in the hospital, and he is in order to avoid his suffering, in order to agonies, painful, and for the, just like Aruna Shanbaugh's case, she was in vegetative, not eating anything. She was just lying and not responding, not this organs were not responding to the treatment, or otherwise, in order to see in such a situation, by considering the condition of such these patients, in such kind of patient, so right to die with dignity, life should not right, no, there is a right to life, but right to die with dignity, wherever is needed. This is today's my discussion, my कानूनी चर्चा। तो मुझे लगता है कि ये काफ़ी हुआ, और मैं कुछ और मैंने जैसे पीछे बात की थी आर्टिकल 14 पे भी बात करेंगे, और गोल्डन ट्रायंगल का जो तीसरा रह गया आर्टिकल 19 पे बात करूंगा। लेकिन मैं इससे पहले चाहता हूं कि मैं जो नेक्स्ट एपिसोड करूं, वो व्यूअर्स ने मुझे कहा, कुछ कमेंट्स आ रहे हैं, ऐसे ही बातें हो रही हैं, और जो मुझे फ़ोन आते हैं, बात करते हैं, तो जो मेरे लॉ स्टूडेंट्स हैं, हमारे लॉयर्स हैं, जजेस भी हैं, तो मैं नेक्स्ट एपिसोड उन्होंने कहा कि इस पे मोटर व्हीकल एक्ट पे करेंगे। उसमें मैंने एक और अच्छा है, गुड स्मॉल्टेरियन, जो आप गुड स्मॉल्टेरियन कैन बी a medical from a layman, anybody when you see some accident being happened and intervene, bluntly intervene. He is not a medically expert. In that case, he take the patient, lift the patient from the spot bluntly and bring him in a hospital or provides him. So in another situation, when somebody is medical expert and provides this medical treatment on spot, if the emergency is involved. In this topic, good Samaritan, there are also rules on this topic, and it is related to Motor Vehicle Act Amendment 2019. It is section 134A of मोटर व्हीकल एक्ट। मुझे इजाज़त दीजिए। तो मैं यही कहूँगा कि ये जो मैंने आज बात की है, इसको आगे पहुँचाएं लोगों तक। जो लोग खुद समझ सकते हैं उनको तो ठीक है, जो हमारे लॉयर्स हैं और जो जिस लॉ स्टूडेंट्स हैं, लीगल सर्विस अथॉरिटी के रिलेटेड जो सेक्रेटरीज हैं, हमारे टेल्सा के हैं, और जो जहाँ पे भी काम करते हैं सेल्सा में, तो उनको भी मैं एक रिक्वेस्ट करूँगा, प्रार्थना करूँगा कि वो भी जो मेरी बात है, जो अपनी तरफ से जो भी है, इन जो ये टॉपिक्स हैं, तो ताकि जो हमारी कानून की बातें हैं, कानून की चर्चा है, आम लोगों तक पहुँचे। तो थैंक यू। जो चैनल आपका है, इसको सब्सक्राइब करो, और इस जो एपिसोड अगर आपको अच्छा लगा तो लाइक करो, शेयर करो। थैंक यू वेरी